It's not about grabbing hold of the set of keys, trouser in as much cash as you can, and running away from any responsibility thinking, hey, the guy who owns the building's going to pick up the shortfall.
A landmark new court ruling clears the air and offers certainty for rent-to-rent operators. In this video, we'll take a look at what this is all about and what it means and what you need to know if you're doing the rent-to-rent strategy. I'm joined, as always, by Andrew Roberts. Andrew, how you doing?
Hi, Ranjan. This is great, isn't it? I mean, it's nice that a court has actually made things clear for a change.
Yes, exactly. And I mean, just to summarize what goes on here, you rent a property from a landlord and then you do something to it sometimes and then you rent it out to tenants. So you're, as a rent-to-rent operator, sitting in the middle. Something goes wrong, who is responsible? Who bears the responsibility? Is it the rent-to-rent operator or the ultimate landlord? In the commercial property world, well, it's always the operator in the middle. You might be renting a building to a hotel operator who chooses to rent it out basically and operate that site as a hotel. If there's a problem, health and safety or whatever to do with the hotel, that's never for the ultimate owner, that's for the hotel operator. But for some reason, with rent-to-rent, with residential property, there's been ambiguity.
Well, I'm glad that ambiguity has now been cleared up. I mean, to me, it's...
Why do you think there was ambiguity? To me, it's crystal clear.
Well, to me, it's always been reasonably clear as well. If you are renting a property off a landlord and you're going to convert it to a HMO or a rent to serviced accommodation, then you are the person running the business, you have the contract with the tenant or with the customer, and therefore you are responsible. That means you're responsible for making sure you've got the relevant licenses, fire protections, inspections done on the property. It's not about grabbing hold of the set of keys, trouser in as much cash as you can, and running away from any responsibility thinking, hey, the guy who owns the building's going to pick up the shortfall. That to me is not what it's about. You know, it's about you take ownership of your business.
And I think some people have been going after the ultimate landlord, the ultimate owner, because they assume, well, they own the property, so they've got the resources to cover it. But the thing is, they can have no knowledge of what is going on under their roof, because you will rent a property out to an operator. You'll rent the whole building out for a fixed rent, and you will usually have clauses in there that say what they can and can't do. In other words, operate it as HMO or serviced accommodation. And you will have a clause in there that says that they have to adhere to all the regulations that are in place at any one time.
Absolutely.
And indemnify the ultimate landlord.
Yeah. Well, I mean, if I can just tweak some of the language we're using here, I think what we should be saying is the landlord leases the property because they lease it, they offer it on a license, which is different to renting. Renting tends to be on an AST. So they are leasing the property and then it is being rented by somebody else to a third party. So to me, what is happening here is unscrupulous rent-to-rent operators have tried to duck out of their liabilities. We saw this during COVID times when rent-to-renters were going, here's the keys, have them back, we're not paying you, because their business is imploded. And similarly, we've seen people running rent-to-rent operations and they've not licensed HMOs, they've not got them up to the required standards, and therefore they are getting in trouble with the council. You cannot hold the building owner responsible when they don't have access, they don't have knowledge, and they've given a lease to somebody for them to operate their business out of.
I don't see why I don't even understand why this went to court, quite frankly, because a lease is a lease. Now, if you look at a freeholder owns a block of apartments and those apartments are sold on long leases, so they may be a 125-year lease.
Yeah.
So if someone then owns the 125-year lease and then rents it out on an AST, and they do something wrong, say they're fall foul of HMO legislation or whatever it is, who is responsible?
Yeah.
It's not the freeholder, surely, because the freeholder doesn't have the access to that apartment or whatever. They have leased it on a 125-year basis on fairly strict terms. If someone has then taken that lease and done something else in that property, that's for them to answer.
Totally. And, if you don't have access and you don't have knowledge of something, how can you be held liable for it? Especially if you've got a contract that says responsibility passes to a third party. In this particular case that was heard before the court, the landlord had a clear agreement, a written contract with the rent-to-rent business, and the rent-to-rent business breached the terms of the agreement. They were letting out for longer than they should have done. They were letting without a license. They hadn't done the compliance. The landlord had written into the contract, they must do this. So how can it not be anything other than the rent-to-rent operator's responsibility?
Yes, I mean, I think this is a massive can of worms which has now been sort of rectified. But we do wait to see what's in the Renters' Rights Bill to see whether this will have a play on how this scenario will unfold in the future.
Don't get me started, Ranjan. I mean, come on. It's called the Renters' Rights Bill. It basically means that potentially they could go up to your bank and make a claim on the bank, because technically it's the bank who owns the majority of the property if you've got a mortgage on it.
That's very true. That's very true.
Because most people are on more than 50% loan to value, therefore the bank owns the majority of share of that property. So to me, I think this shouldn't have gone to court like you. I think it's an open and shut case. If you're a landlord, some tips for you. What you should be doing is due diligence on the operator. Don't just put it into the contract. Demand copies of and sight of any agreements, such as a HMO license. Copy of the application, copy the fees paid, copy of the approval, and follow up in your diary system to make sure that that is done. Make sure if it's been run as a HMO, you get the fire safety certificate and fire policy in hand. And again, if you're a renter, make sure you are doing this proactively to give a landlord comfort.
Yeah, I'm just thinking about what you're saying. As you're saying all of that, I was thinking, well, might as well do it myself. I guess you could do that, but then you're getting involved in a lot of the business operations of the operator and checking their compliance. I think what I would probably prefer to do is to make sure that the operator had a track record of other properties that they're doing. Because if you want to rent from a landlord's perspective, you often want that hassle-free. You don't really want to know too much of what's going on. You just want to know that you have the track record to do it properly and you will comply with everything. I'm not sure whether knowing too much about what's going on puts you in a slightly different position, because you're then putting yourself up as policeman, an overseer of their compliance to regulations as an operator, which is more hassle. And then I don't know. I don't know the answer to the question I'm posing.
I take your point. From my point and where I'm coming from, if I'm a lender and I'm lending money to you, I want to know that you've got the planning permission. I want to make sure that you've got the licenses. So a lender will demand of you that you've got the relevant compliance. What I'm saying is it's your responsibility, and if you don't do these things, then you're in breach of your agreement with me and it's terminated.
Yes, yes.
So I'm just making sure that I don't end up spuriously spending thousands defending a court case that I should not be involved in and demonstrating documentary evidence that it is that person's responsibility to do it. It's there in my contract, and they haven't done it, therefore I have a right to terminate that contract.
Yeah, having had a reflection, I think you've got a point. I think the issue here is basically that a lot of rent-to-rent operators are new, and a lot of them do not have as much financial standing as the entity that owns the building.
Correct.
It's just a fact, because the building owner owns a building, the rent-to-rent might not have a bag of beans. And in that situation, you've got to be very mindful that that rent-to-rent operator can simply pack
Collapse
up and go.
their operation.
So what you need is what I've always called a marching in clause in your rent-to-rent agreement that you have with the operator, which means that under certain criteria you can march in and take over. And to do that effectively, you do need sight of all this documentation.
Correct. And I totally agree with you, Ranjan, and that is why I put that forward, that from my perspective, I would want to make sure everything is whiter than white and squeaky clean. Your lender would demand it of you, so why wouldn't the rent-to-rent operator?
And if you want to meet 300 squeaky clean property investors, the place to go is the Baker Street Property Meet. We meet once every month in central London. It's the largest property networking event in the UK. Come and join us at this month's meeting, bakerstreetpropertymeet.com.